Well, hello and welcome to another edition of Reimagining Law. I'm Mark Palmer with the Illinois Supreme Court Commission on Professionalism. There's been a national movement in criminal justice reform to rethink and improve the many aspects of pretrial practices, from arrest and first appearances to bail and supervision. The Illinois courts and the criminal justice system are no exception. To talk about the recent examination and recommendations involving related pretrial laws, rules, policies, practices, and procedures in Illinois, I have two individuals who not only have been part of those recommendations and determinations, they have experienced them firsthand throughout their own careers. Judge Robbin Stuckert is the presiding circuit judge in DeKalb County for Illinois' 23rd Judicial Circuit, alongside Keith Grant, the Public Defender Division Chief for Lake County, Illinois. Judge Stuckert and Attorney Grant served on the Illinois Supreme Court Commission on Pretrial Practices and its subsequent implementation task force, of which Judge Stuckert has served and continues to serve as chair. Thank you so much, both of you, for joining me.
Thank you for having us.
Thank you.
So to set the stage, Illinois created the Pretrial Practices Act back in the mid-'80s. And that provided a legal framework for Illinois courts to have a pretrial process. Then fast forward about 30 years, Illinois Supreme Court created the Commission on Pretrial Practices in 2017. Fast forward again to April of just last year, 2020, you come forward to the Illinois Supreme Court with a massive report, an 86-page report with 54 recommendations over this 2-year study. Quite a lot to chew on. How did the court respond to this?
Well, when I appeared before the Supreme Court with our report, I was greeted with an enthusiastic, great report. Let's get started. You have a lot of work to do. And it was an enthusiastic response from the court, which we were very pleased with. But they did acknowledge that because of the volume of the report, and again, there's not one aspect of pretrial. It starts from the very first time an individual is involved with law enforcement all the way through the adjudication of the case. And that was why it is such a large report that we did, because we didn't look at just one aspect of pretrial. We looked at what really is an essential high-functioning pretrial, which is the desire for the state of Illinois. So we were told, let's get a task force going. And so we implemented the task force and we began meeting in the summer of last year. One of the aspects that impacted all of us was we were hopeful that we could roll out our report and educate the community and stakeholders with our work, but something called COVID impacted us as well. So it kind of limited our ability to really educate Illinois on what we had been doing for a very long period of time. So then the task force came about, and just like the commission, the task force is representative of a bipartisan and multidisciplinary group, and we've been meeting bi-weekly since last summer when we convened. Our very first goal was to take this massive recommendations, as you've said, in our report, and identify and really narrow down which of the 56 recommendations form the foundation for a high-functioning pretrial system for our state. For example, all of us agreed that accurate data is necessary to review and assess the efficacy of state system-wide change and outcomes. So we really need to focus and develop on and implement a statewide data collection system and enhance current systems, and we need financial resources to do that. So what we started doing was looking at the report, looking at those foundational recommendations that are so necessary for the beginning of change and formation of efficient pretrial, and identify those with subcommittees studying those. And as the subcommittees come up with their ideas for implementation, they bring them to the task force. Once we agree, then it's sent off to the Supreme Court. So it's an ongoing group of summaries that we are providing to the court as we go along.
Keith, I want to turn to you from your vantage point, you being a career public defender in Lake County, Illinois, kind of stepping back from the report itself and your work on the commission and the task force. What have you seen in your career in the last 30 years in Illinois and how we've addressed pretrial issues, and how, in fact, does pretrial issues impact your job as a public defender and all the public defenders across Illinois?
The one consistent factor in being a public defender is who we represent. We represent the indigent accused, the people who do not have the financial wherewithal to retain counsel. And therefore, it is far more difficult for them to come up with the financial means to secure their release. Over the course of over 20 years of doing this, and since I became involved with the Illinois Public Defender Association and working with public defenders across the state, it is consistent that our clients will end up oftentimes incarcerated because they are unable to secure their release through financial means. And that has been the stock and trade of the pretrial system. I've kind of come to see that money does not necessarily ensure safety. In fact, the studies that we've looked at as a commission indicate that it's irrelevant as to community safety or even return to court. When I came to the commission, it was as the sole public defender on the commission, and I walked in and sat down the first time and saw all of the judges and law enforcement and former judges and more judges, and thought, wow, this is going to be interesting. And in the course of a very few number of meetings, especially with the guidance and support of Lori Evil, we were able to all begin to see what works and what doesn't, what is and what isn't best practices, and that Illinois needed to move to a place where money was at least irrelevant in making determinations as to who is and who isn't detained, because it is irrelevant in itself as to public safety or return to court.
Well, this issue is certainly at the top of the agenda as far as criminal justice reform at the moment in Illinois, that's for sure. I want to give you both an opportunity to talk about the interplay between your work in the past 2 years and going forward and the police and criminal justice reform bill that was signed into law in Illinois, which includes an abolishment of cash bail by the year 2023. How are these two things related, and how do you balance the two, especially when you're dealing with interplay between, frankly, two branches of government, and you could even say all three branches when you bring in the executive branch to execute all the operational aspects of these issues? Judge Stuckert, why don't we turn to you first?
Certainly. Members of the task force were also in discussion with legislators and advocates regarding criminal justice reform legislation. So when we were meeting with our biweekly meeting with the task force, during the other week, we were meeting with legislators and advocates. And what we were doing is we were listening again to one another, and we worked to align the pretrial aspects of the bill as much as possible with recommendations of the commission's final report. We did not agree on all aspects, but we worked really closely together with the legislators as well, not only to give our perspective, but to educate them on the process and what we had done in the 2 years as a commission. So we explained our recommendations, how we came to our recommendations, and a consensus was formed with the commission. So we have been working very, very closely, and we are encouraged as well, enthusiastic about continuing to work with the legislators. There has been indications from the sponsor that they are looking to the task force as well and to other stakeholders as to any necessary amendments that would ensure, as we go forward, that we have an efficient pretrial system, first of all, that works but is sustainable in the state of Illinois as well. So we are really encouraged with the interplay that we continue to have.
Keith, can you add to that?
I'd say that moving forward, we've eliminated cash from the equation, which means that now we're going to be talking about other conditions and whether or not our clients are going to be released at all. The members of the commission, the judges, the legislators, even law enforcement who participated in the commission's 2-year journey were educated and in this idea, and did come to see that detention is not necessary in most, even many cases, and therefore are where we need to be. Now we need to do the hard work of educating the rest of both bench and bar and the general public to understand that we are as safe as we need to be when not every single defendant is detained. My fellow public defenders across the state are now going to have to fight every day to ensure that the least restrictive means necessary for public safety and their clients' return to court are what are imposed. And that's going to mean changing perception of what has been done in the past. The old idea is that you need quote unquote skin in the game, or that you have to put up something that's yours to ensure safety and return to court. Those things have been proven to not necessarily be true. And our attorneys are going to need to find ways to impress that upon not only courts, but prosecutors and the general public, who are going to be observing very closely what takes place in our bond courts across the state.
And I want to remind our viewers, we will include links down in the notes of the report of the commission that came out in April 2020, and as well as other further work that the commission's task force to implement the report is doing along the way. Last question for both of you. Let's say the three of us were to have a conversation 2 years from now, hopefully in person once these pandemic safety protocols are over and we're back to some type of normalcy. What would you hope would be the current situation of the task force and pretrial services in general in Illinois, say 2 years from now, if we were describing it and you were successfully on that path? Keith, why don't we go with you first?
Well, from the vantage point of a public defender who is also a commission member, one of the things that I was principally responsible for was first appearances, where our clients first come into the courtroom and have to appear in court. And we created a subcommittee of prosecutors, judges, and defenders to look at what that means to have effective representation at a first appearance. And that's going to need to change over the course of the next 2 years. Public defenders are going to need to be in every single first appearance courtroom across the state. In counties where there is but a single attorney acting as public defender and he or she is often in private practice as well, that's going to be difficult, and changes are going to be necessary. In locations where courthouses are geographically not located near detention facilities or jails, and where they do those hearings sometimes remotely, things are going to need to change so that we have the ability to consult with our clients before they appear in court in a confidential and a secure manner in every courtroom. These changes are going to have to be made, and right now there is a roadmap for them in the legislation, but there right now is no funding. And we're going to need to increase the number of public defenders across the state, increase their access to the information that they receive, and increase their secure and confidential access to their clients, so that that defendant can have best presented to the court all of the facts and circumstances that lead to a determination of what would be the least restrictive means necessary to ensure both public safety and our clients' return to court.
I would agree with many of the aspects which Keith has just spoken about. 2 years from now, right now when we were studying nationwide, and we all talked about the gold standard in pretrial state, and many of us had looked at New Jersey, and historically through the nation at this time, we all look to New Jersey and we say they're the gold standard. In 2 years, I would love nothing more than to look at Illinois and say, boy, Illinois got it right. They methodically looked at this. They didn't rush into anything. They looked, they processed, they looked at barriers, they addressed the barriers, and they found solutions to a problem. This has been historical legislation, and historical legislation that has been needed. But for all of us, we have approached pretrial, which has made it difficult and has perhaps made it emotional, because we all look at pretrial reform through different lenses, and our historical lenses. And to change that, change always starts with education. And this is an emotional issue. All you have to do is look at the newspaper articles and what has been said just in the last several weeks. And this is an emotional issue. But we all can come to an understanding. We can all work together, and I'm confident that we can, to implement, again, this historical and must-needed legislation so that bail practices and pretrial practices are the gold standard, and we will be looked upon and say, again, Illinois did it right. I think it's education, 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 discussion. But I will let you know, I talked to a legislator the other day who said, aren't you concerned that if someone doesn't post bond, Judge, you'll never see him in court again? Because we do know if you post a cash amount, that ensures that you come back to court. And I said, we would all like to believe that. Because maybe in our own minds, we say, well, if I put up $2,000 or something, if I were in the criminal justice system, I would return to court. We deal with a population that may not think with that type of process. And many people don't come to court because of barriers that are set up. I have a job, I can't miss job, or I lose my job, I have no transportation. There are so many various reasons why people. But as I explained to the legislator, I assure you, I've learned something in 20 years. If someone fails to appear, their first thought isn't, I'm going to lose that cash that I posted.
Right.
Not at all. And I assure you that if someone is about to commit a criminal offense, they don't stop and go, whoa, I'm going to lose that $1,000 I posted for bond. It does not go into the equation. It does not make us safe. It doesn't do what we all want to succeed in doing in effective pretrial. But it's taking a mindset. We have to educate people, as Keith said. We have to have these discussions. And I mean, this was a gentleman that was on our commission, and even is saying that to me 2 years after being on our commission, that bail and cash means something. And we know that it doesn't. Those of us who are studying it and embraced it, we know it doesn't. But again, this is a real emotional topic. People are coming with it with a lot of emotion. And when that happens, we got to get past that first. And that's the difficult part, is getting past the emotion of this legislation.
Well, very well said. I can't express my appreciation to both of you enough for coming on and helping explain the situation we are in Illinois, where we're going, and sharing your personal thoughts and views, and especially the work you're doing with the commission. We thank you for that especially. Thank you so much for joining me.
Thank you.
Thank you for the opportunity.
And all of you, thank you for watching. Please share this video with others who may benefit, and subscribe to the channel of the Commission on Professionalism for more updates and new episodes. There's links in the description below as always. Thank you for watching, and be well.